Yes, my lord, I am praying leave to file appeal without certified copy. There are 8 appeals are there. Same point, and I will
bench order.
single bench order, vacation bench order, and
The urgency, Mr.
my lord, urgency is this, my lord. This is SSC. Your lordship knows that the it has to be done by the 31st December. The result. Some orders have been passed, my lord, which is required to be need to examination by the appeal court. My lord, and the stay petitions are there. Then these stay petitions may come on 29th. I am not pressing on Monday and Tuesday. If it is possible.
The returnable date as 29th. Ask your junior.
And the grounds of appeal, etc. Kindly give the leave.
Yes.
Well, I'm seeking your lordship's leave, to these matters, if preferably today or on Monday. The immediate urgency is,
Yes.
let it appear on Monday. Let it appear on Monday. All these matters. There are two appeals. The urgency, fresh matter. The matters were taken up by the division bench, decided during the vacation, and it was directed to be listed on the reopening or mention. But I'm bringing, this is pertaining to nursing examination.
Serve notice.
Yes, upon notice. And Mr. Chatterjee, Mr. Nilotpal Chatterjee is here. He was appearing for, and may it appear on Monday.
Tuesday.
Look, kindly
may I permitted to mention? Yes, I get 2 points.
Well, as this is a specially assigned matter, your lordships, where I had mentioned this matter before vacations as well. Well, as this was a matter where a division bench, the Justice Banerjee's led bench and Justice Chondo both arrived at different conclusions in respect of refund of EMD amount. The matter was subsequently placed before the Chief Justice, and the Chief Justice assigned it to your lordship. Now, my lord, the urgency is this: my client has already gone through 1 round of litigation.
Justice Banerjee and Justice
Chondo, my lords. Both arrived at 2 separate.
Justice Orijit Banerjee.
Yes, Orijit Banerjee. My lords, the impugned judgment was passed on 5th of April. Whereas the urgency, I tell your lordship, 1 round of litigation. No. Oh, yes, your lordship. I'm sorry.
Are you mentioning about notice?
I don't think so. I don't think the advocate had record as mentioned.
You survey notice original side আমরা কবে নি 6th November এটা দিন না উনি মেনশন করবেন ওকে বলবে এখানে অরিজিনাল সাইডে কি আছে না you give a notice and mention before us on
Tuesday
and Thursday.
Permitted to mention, I am praying for leave for file and can application because matter will appear on 27 until and unless my lord endorse with the leave application. The matter will not appear in the list. Why?
Can application
in connection with the memo of appeal? Because of that, my lord will remember.
Which we have fixed on
27, because in the meanwhile, interregnum period, my lord, the vacation period on the 25th September.
This mentioning made by Mr. Bandyopadhyay, that matter?
No. This is, my lord, regarding on a TET 2022 wrong question matter. My lord will remember Mr. Bhattacharya, my senior, because Mr. Bhattacharya appear in the last day of the regular court, my lord.
Notice and come back on.
My lord, this is a CAN application. Why is this CAN application I am filing? Because of the in the interregnum period.
When we have made it returnable
on 27th. Otherwise, my lord, matter will not came in the list. Yes, my lord. That's the urgency.
Why you are filing it here?
Because of on 25th September 2025, West Bengal Board of Primary Education published a notice.
So you file it in the department?
It did not came, my lord, until and unless, my lord, endorse, because due to 48 hours. Sorry.
Two mandamus appeal, both to appear after puja vacation in 2024. Order given by Justice Bakshi and Justice Kant. Two mandamus appeal. One is.
Are you mentioning upon notice, Mr. Chakut?
Well, there was a direction to appear in the list. There was a.
When did we direct it to appear?
It was supposed to appear on 8/11/2024. It was the assignment.
24.
Yes.
Before some other bench, maybe.
No, it was assigned. It was before Justice Bakshi and Justice Kanant.
It was not before us.
Not that time. It was not
Give
before
a
us.
notice to your other side and mention on Monday. Then we can consider it. Yes.
May I have my lord's kind leave to mention on habeas corpus application. This was heard by the honorable vacation bench and liberty was given to appear the matter in the regular bench. My lord, kindly have.
Milord, may I permitted to mention?
I will serve notice in due course of the day.
Uh-huh.
In due course of the day, I will serve the
No,
notice.
no, you serve notice and mention on Monday.
Great.
Yes.
My lord, my senior is
May,
appearing.
may, I- may I allow my lord the mention?
Wait, we will come back to you. Yes.
Yes, yes, my junior, she is my junior, my lord.
Yes.
My lord, I want to file an intercourt mandamus appeal without certified copy. My lord, the order was passed on 14th October during vacation. My lord, this is extremely urgent. My lord, I have been illegally transferred by way of punishment. After there is a charge against me, defalcation of money. But the lawsuit, my lord, this is extremely urgent. Let it appear on Tuesday, my lord, so that kindly, my lord,
Appear on Thursday, you give a notice to them. Thursday.
yes, yes. Thursday, no, my lord, 11.
তাহলে বুধবার দিয়ে দাও। Thursday is a holiday. Wednesday তাহলে দিয়ে দাও।
Wednesday.
4th November দিয়ে দাও। Yes.
4th November. No, my lord, there is an urgency because the 13th, my lord, the managing committee.
We have
Because-
4th.
No, 4th, my lord, that will be problem because the 13th October managing committee adopted a resolution to release me. If the release order is passed, I have to join within 3 days.
We have kept it on 29th, Wednesday.
I get full dollars. I get full dollars.
Taku disturb করবো না।
My lord, I am for the petitioner. I am praying for not today.
First matter after vacation and you are praying for?
Not today, my lord.
Why?
Not today. My lord, I am led by Mr. Sudipta Dasgupta. He is engaged in court number 18, your lordship.
Very good. You place the order. What is the order? This is the first time it has come.
No, no, my lord.
It is an. So what is that? You have been given copies. You have been served.
Lord, we have received it. No?
Monday week করে দেবে। Monday week. Yes.
We are grateful, my lord.
Monday week. Oh, Monday week will be combined list, na? The 6 তারিখ দিয়ে দাও। 6th থেকে।
My lord.
My lord, in this item, I am also praying for not today. Actually, I engage this matter in this matter, Mr. Samimul Bari. He is not came today. My lord, that's why.
6th. When
6 minutes. Grateful, my lord.
Amendment 3, my lord, Mr. Pottonaik is appearing on behalf of the respondent in this matter. He has some medical difficulty today. He has not come before this court. I'm praying for not today, my lord.
It is at the.
We've had a hat trick of adjournments.
Yes. That's the reason I told that কপালে থাকা চাই।
6th
Same person. Same person.
6 তারিখ ওই উপরের দিকে দিয়ে দিও। যেরকম আছে।
I get.
Yes, Mr. Vadradi, why is the show such dull? We don't find advocates today.
in a confusion as to whether, because of
What happened?
till date I have not got any information. I was also expecting that the Ballaberi will be taking a resolution.
Yeah. Yes, I'm happy. Well, this Honorable Supreme Court, they passed this order because as the appeal is pending, well,
You have obtained the certified copy.
no, I have not obtained certified copy right now.
Did you apply?
Yes, yes.
When did you apply?
Oh, very next day.
Yes, tell us.
Another thing, my lord, that after the appeal has been filed, another interlocutory order has challenged before the Honorable Supreme Court. And because in all the cases on the order passed without any registration of case, without any case number, that is why Supreme Court refused to entertain any SLP. Thereafter, Supreme Court entertained the SLP and with the direction that the contention made, all the contention, the pending appeal should be raised before this appeal, in this appeal. So I can file the the SLP, the petition along with the all annexure, that I can file to along with this appeal.
After this order was passed, you went up to Supreme Court.
It was before I filed SLP before final order was passed. Thereafter, Justice Bakshi pointed out that the appeal is pending, intercourt appeal is pending. So therefore, in this appeal, the contention in this appeal should be raised also here. Almost same thing. Say all annexed I have called in my appeal. There is nothing new, but some new.
You want to use a supplementary evidence.
By way of supplementary with the SLP, which has been filed before the Supreme Court, that is ready. I can just file an affidavit.
Who is opposing you, Mr. Chakraborty?
There is no opposition because
no, it was court on its motion did.
The board, but so there was earlier there was a direction by the Supreme Court before the division bench, but the justice single bench passed order in a different civil appeal, civil content. So I had to take permission, leave from the Supreme Court to file to make myself party in the appeal. Otherwise, I could not have filed because I was not a party in this case. This Urunam Chakraborty versus Partha Ghosh. The case was Partha Ghosh versus Rabindra Bharati University. I was not a party, but court passed several orders in that appeal. So I challenged that order before the Supreme Court. How could I be? Why could court pass such an order when there is no case has been registered? When so there, yes, that is then Supreme Court said as the intercourt appeal is pending, so it is become infructuous. So all the points raised before the Supreme Court can be raised here. But though only some document has to be placed before the just to add the appeal. I can file the total entire SLP along with the document by way of affidavit. That is ready. I can file Monday and it can be listed on one.
That is 24 এপ্রিল 2025 23/5 এই ট্যাগার গুলো নেই একটা ট্যাগার
As there is an order, that's why I brought this notice.
original application.
It's appeared from files.
No, who was the original order in the appeal were Partho Ghosh and State of West Bengal.
Original order was passed because in the said order, original order was passed in
That
the
is 24th April 25.
that is before Partho Ghosh and Ravindra. I was not a party in that case.
Very good. Now let us understand. Now Partho Ghosh filed a contempt petition.
Yes.
So that contempt and the main writ petitions were heard together.
Yes.
And an order was passed.
No. After the writ petition, a contempt petition was filed by the Partho Ghosh against the university. I was there. I attended as an advocate, not as a party.
Appeared for whom? Did
For the respondent registrar of the university. Therefore, the single bench passed several orders in the said contempt appeal and passed several orders which is beyond the scope of a contempt petition. And that was challenged because in a contempt petition, court cannot travel beyond the four corners of the order against which the violation of which challenged. Therefore, in the said several orders, earlier also, and the case was registered after 1 year beyond the limitation period. The case was registered 5th of May 2025 beyond limitation period. Therefore, on that ground alone, this contempt, this proceeding initiated is liable to be set aside.
Now, did you serve the connected application upon the office of the Advocate General?
No, there is, unless court, one thing. As per Calcutta High Court contempt rule, if court feels otherwise in a contempt petition, third party cannot intervene. That is a settled proposition of law.
Third party. With the Suomoto contempt matter, which was
either in Suomoto or in criminal contempt, in Justice Karnan's case, 7-judge constitutional bench categorically held that in a contempt petition, it is between the court and the contemptor. Third party cannot poke its nose.
That period is over. Now we are in appeal against that.
In the appeal, if court feels.
No, we are feeling because of the reason the contempt, Suomoto contempt order was passed in presence of the Advocate General. This order of 23rd May, against which you have come up in appeal.
Actually, what happened background? What is the background is that?
No, not the background.
No.
The court on its own motion is the respondent.
No, my lord, what happened? Justice Bosak asked the Advocate General to approach the single judge for a solution, settlement. But Advocate General was not made a party by the court. Court recorded that in the presence of the Advocate General. But there was no such order as per the provisions of the contempt rule, which is mandatory, Calcutta High Court Contempt Rule 1975. Advocate General, if the court feels that Advocate General should be made party, there should be an order. There is no such order. Kindly can have looked at the contempt rule. Contempt rule, Rule 34 of the Calcutta High Court Contempt Rule 1975. Kindly have a look. আমার দিয়ে দিন সেক্টর এটা দিয়ে দিন না পারেন এটা দিয়ে দিন না মানে 34 can look at চ্যালেঞ্জ হয়েছিল ওটার পরে ওটা সুপ্রিম কোর্টে এসেছিল কিন্তু সুপ্রিম কোর্ট বললো যে এই কন্টেন্টস রেজড হিয়ার এই কন্টেন্ট অন্য কোনো না ক্রিমিনাল ওই অর্ডারটা শুধু যেটা পানিশমেন্ট দিয়েছিল সেই অর্ডারটা
Are you appearing?
But so far Partho Ghosh is concerned, writ petition I was filed in contempt, my lord, I have filed the contempt petition. And in contempt proceeding, my lord, two types of order have been passed. One against the alleged contemners, and my lord, what shall I say, my lord, his conduct, attitude, etc. My lord.
One against Mr. Chokku.
Yes. Now, the challenging
the order has been complied.
Order has been complied with. Lord,
You are for the
writ petitioner, the writ petitioner applicant.
That is Partho Ghosh.
Partho Ghosh. And what the one contempt rule, criminal contempt rule was issued as per section 16 of the Contempt Act. That was not placed before the Honorable Division Bench, Honorable Chief Justice, and it was not assigned before the Honorable Justice Bosak Division Bench. And that Division Bench, Bosak, my lord, initially passed an order directing him to serve a copy of the application along with all the annexures. It was not served. Certain orders were passed. Lord, then he filed a review application. Now, review application has been dismissed. Against that, Lord, as per my knowledge, he filed two SLP. SLP were
Have you got copies of these documents from Mr. Chakraborty?
No copy has been given to me. And Lord, the last order, Lord,
you are not a party in this appeal.
Maybe.
Contempt appeal.
Lord, maybe. I do not know whether they have made me a party or not. Now, Lord, the last order, before the Honorable Division Bench, when the Justice Bosak had taken up the matter,
because his argument we have to consider. Let that come in the file, and if we think that your presence would be necessary, then we will pass consequences.
yes.
Well, this required. But as Supreme Court, there is a direction clearly by Supreme Court, so I have need to submit the entire SLP.
That is what we have said.
Yes, yes.
File the supplementary letter.
Yes,
Yes,
you will solve list, solve date kindly. Monday I will file.
we have you file it by 4th, it will appear on 11th.
4th, Mr. Hey, wait. Calcutta High Court appellate side contempt rule as per mandate of the Honorable Supreme is a mandate.
My lord, Mr. Gautam Banerjee, an advocate, has requested me to take time.
6th November.
Lordship. For item numbers, Lordship, I am applying for the state respondent, Lordship. In this matter, we have filed the review application, Lordship. And on the last occasion, we have also filed one CAN application regarding the addition of ground or in the review application. Lordship, Lordship, in this matter, Lordship, I am led by Supratim Thor, and now presently Advocate General will need us. Lordship, if your Lordship kindly
Filed a review against which order? Oh, review is also appearing.
Yes, Lordship.
Well, this is the jury finalis matter. Division bench will set aside the order of resumption on the 6-3, challenged by the state before the Supreme Court. SLP on merits dismissed. Thereafter, they have filed a review application. So, this review application was pending for almost 8 years. Finally, we got an order from your lordship for reconstruction.
Sure.
So that reconstruction has also been undertaken. Now they have filed an application for amendment of the memorandum of review.
Not
That is one.
additional grounds. Additional.
So basically, they seek amendment of the memorandum of whatever, additional grounds in the memorandum of review. That is one application. And there's another application which is filed along with the review, which is the application for condonation of delay.
For
Review. So that's about 800 days delay is there. So what I was respectfully submitting, since they're asking for time, kindly give us directions for using affidavit in both the applications so that when the matter is returnable, it can be finally heard.
This application for condonation was filed along with
the memorandum of review.
But why didn't you be using the big time? Because that was
never taken up.
19.
Never taken up. No directions passed. Never taken up.
Reconstruction has been made, Lordship. We have. Lordship.
And there is one more connected contempt application which has been taken out by us.
That is already in the list.
Yes, it is. It is.
Now it has been reconstructed.
Yes.
But there are 2 review applications.
My lord, there were 2 writ petitions.
Oh,
common judgment.
Oh.
Then Supreme Court. So they have filed 2 separate review applications. সে বলেছে বড়
Lordship, already.
Yes, yes, we have received all the amendment application. Additional. এখন তো নতুন নম্বর পড়বে 1 2 করে কিন্তু যেহেতু 2019
এই অ্যাপ্লিকেশন গুলো তো নাম্বার হয়েছে নিশ্চয়ই। এই যে
ক্যান 1 ক্যান 2 থাকবে না
অ্যাপ্লিকেশন
না কোনটা কানেক্টেড টু which one
অ্যাপ্লিকেশন 968
কানেকশন অ্যাপ্লিকেশন ক্যান 3 হচ্ছে অ্যাডিশনাল গ্রাউন্ড কানেকশনে ক্যান 1 My lord, can number 9687 of 2019.
and the fresh application for
Can 1, can 2,
No, that is scan 1 is scan 3,
can
which is in connection with RVW 165.
আচ্ছা তার মানে ওই নাম্বার হচ্ছে 1
Oh,
9681
tick. I am told that, my lord, the original CAN applications have now all been renumbered.
Correct.
Yes, and they have all become 1, 2, 3.
So just have a look at the list, Mr. Bose.
My
Just
lord.
tell us which is the condonation application.
My lord. List dekhe bolun. List din.
You'll find both numbers given in the list.
Yes, ma'am.
Yeah.
Grateful. Judgeship list. Dekhe bolun. Condonation of delay application ta konta. Content.
এটা contempt যেগুলো রিভিউ এর সঙ্গে
এই যে
থাকবে।
ক্যান গুলো আছে কোনটা কার না সেটার কথা বলছে না ক্যান 1 ইজ ওল্ড ক্যান এই তো 9687 Look, your lordship will find there is one old can 9687
applications
Yes.
old number was 9680 and 968 something
9680
no, my lord, one possibly is 9687
and the
and
other
the other is 9691
so those are two condonation
Mile.
applications in connection with two review over and above they have filed can 3 a separate application for amendment so you are wanting leave to use opposition to those
both.
three applications very good
Lord, I am for the appellant in this matter. Lord,
You are ready, Mr. Bhattacharya, we can take it up. No adjournment required.
Lord, perhaps your lordship will remember before vacation.
You are not ready.
I am ready. I am ready. Before vacation, I concluded my argument. In the meantime, long days has gone. In the meantime, perhaps all of us may forgotten the submission which have been made. But I don't know whether my lord can remember or not. But if your lordship permits me,
Once we
I
see
can-
our note,
I can take only 5 minutes to recapitulate the matter. কত তারিখে হয়েছে না লাস্ট ডেট কবে হয়েছে তুমি এটা বলো না বলো না it has been transferred here and it has been assigned to my lord.
it has been assigned.
First of all, your lordship heard this matter. On 15th of July, hearing was concluded. My lord's order.
Hearing wasn't concluded. You concluded your submission.
Appellant's hearing was concluded on 15th of July by my lord.
Correct.
Thereafter, on the change of determination, matter went to court number 13, before my lord Justice Manta. So, wherein, my lord, after going through my lord's order, their lordships were pleased to direct to have the matter assigned before my lord. And, my lord, accordingly, after assignment, it has come to my lord. Now, my lord, in the meantime, 2-3 months has gone. I have also forgotten however I have submitted, and my lord may forgotten. I don't any thing to say, my lord. I got my memory to that effect. So, if your lordship desire, I can, my lord, recapitulate my submission within 5 minutes. Or otherwise, my lord, if your lordship yes, my lord, can do it.
Yes, tell us.
But the point involved in this matter,
Yeah, just a moment.
is as to whether, as per the scheme of 1981 or 72, there is any limitation for making application for transfer of pension in favor of the widow or the unmarried daughter of the freedom fighter who was receiving the pension. That is the first point. Second point, as to whether there is any income bar or not. That is the 2 point. Mainly, the writ application has been dismissed on the ground of delay of filing the application. Please, that my father died in 1996.
2 points are, one is limitation and the other is?
Other is as to the income bar. How far?
Eligibility of the person who's asking for the transfer of the pension, if she or he is earning something from some other means.
Yes.
These are the 2 points.
Yes. But the first point I will submit, I submitted and I am submitting that in the...
Take us to the ordered impute.
Yes.
Facts
It has been annexed at page number 65 of the paper book. 65 of the paper book.
4th of October.
65, my lord.
Yes, yes.
Yes, my lord.
Place the order, it will come back to our mind.
My lord, I am placing the order from 65. Learned counsel for the petitioner contends that...
Just a moment. Yes.
Contends that the petitioner is an unmarried dependent daughter of her father who was a freedom fighter and was getting freedom fighter's pension under the Swatantrata Sainik Samman pension scheme. Learned counsel contends that the petitioner's application for the said pension was refused by the respondent authorities initially, upon which a writ petition was moved. Subsequently, the petitioner's application was considered and was refused on the ground of long lapse of time in making the application after expiry of the petitioner's father. The other ground cited by the respondent was that the petitioner was regularly employed from 1979 to 2007 till superannuation. These were the 2 grounds of rejection of the claim of the petitioner. Then the court. It is argued by the learned counsel for the petitioner that it is well settled that the question of limitation has to be looked into liberally by the courts. Learned counsel submits that in a welfare state, the question of limitation cannot be an absolute bar in grant of a relief if the petitioner was otherwise entitled to in law. Learned counsel submits that in civil cases, this court and the Supreme Court has taken a lenient view in such context. It is submitted that the petitioner acted in the Gandhi Ashram, and earned a paltry honorarium. Learned additional Solicitor General states of Madhya Pradesh and another of Bhailal Bhai and others reported in such and such. By placing the particular reliance on paragraph 21 of the same, it is argued that the provisions of the Limitation Act do not as such apply to the grant of relief under Article 226. However, the maximum period fixed by the legislature as the time within which the relief by a suit in a civil court must be brought may ordinarily be taken into be a reasonable standard by which delay in seeking remedy under 226 can be measured. The courts may consider the delay unreasonable even if it is less than the period of limitation prescribed for a civil action for the remedy, but where the delay is more than this period, it is almost always be proper for the court to hold that the said is unreasonable. Pausing here for a moment, the judgment which is
Please continue.
The period of limitation prescribed for recovery of money paid by mistake under the Limitation Act is 3 years from the date when the mistake is known. It is observed, learned Additional Solicitor General reiterates the ground as cited by the respondent authorities and submits that in view of the petitioners having regularly earned an income from 1979 to 2007, it cannot be said that the petitioner is eligible to pension in question. That apart, it is argued that ordinarily statements made have been made in the writ petition. Sorry, that apart, it is argued that contradictory statements have been made in the writ petition. On the one hand, the petitioner claiming that the petitioner is the only unmarried and unemployed daughter of her father, and on the other hand, the petitioner's father left behind his sons and daughters, who are the other legal heirs of the father. The petitioner has solely applied for the family pension, depriving the other legal heirs of the deceased freedom fighter. Moreover, she was not a nominee in the pension account. It is contended. Thus, it is argued the petitioner's application for family pension was rightly rejected under the scheme. A perusal of the scheme in question indicates that after the death of the petitioner, the transfer of pension, the transfer of pension to the spouse daughter will only be considered if she applies for transfer of pension within 6 months from the death.
What is the date of death?
Date of death is, my lord, my father's death is, my lord, 18th of February 1996.
So did his spouse get family pension?
Died before.
After 96?
Before 96.
Oh, predeceased.
Predeceased.
Achha.
Predeceased is my father.
All right. Yes, continue.
The clause 5.2 further stipulates that application received after 6 months shall not be considered by the bank, but referred to the ministry, which shall be taken a view whether to allow dependent pension or not, or whether any areas are to be paid. Clause 6.1.2 indicates that the bank must ensure that a dependent pension is not sanctioned to a spouse or a daughter of a freedom fighter if inter alia the spouse daughter is working in a private sector or having his or her own business activity, then income from such job or activity exceeds rupees 20,000 per month. In the circumstances of the present case, it is found that the petitioner was earning an honorarium from a Gandhi ashram from the year 1979 to 2007 till her superannuation. It is to be noted that the father of the petitioner expired as long back as on February 18, 1996. However, the petitioner made her first claim for family pension only on July 11, 2007. The inordinate delay of 11 years in between is not explained by the petitioner. Moreover, the conduct of the petitioner itself indicates that the reason for the pensioner not to claiming pension, sorry, Miller, the reason for the petitioner not claiming pension previously, despite the demise of her father in the year 1996, was her employment, which continued till 2007 when she was superannuated. The coordinate bench, the coincidence is a bit too much in respect of the year when the petitioner was superannuated from her service and the year when she make an application for family pension, both being in 2007. Thus, the petitioner, for all particular purposes, could not be said to be a dependent of her father, who had earned his rights to getting the freedom fighters pension as per his own acts. The petitioner is merely a chance seeker who waited till her superannuation from a job and only thereafter applied for being eligible for the purpose of getting her father's freedom fighters pension. The scheme in question contemplates honoring the freedom fighters on whose sacrifice the nation stands. It was justified on the part of the respondent authorities to refuse the prayer of the petitioner, not only because the prayer was made after a long lapse of 11 years from the date of demise of her father, but also on the ground that the petitioner was merely seeking to take a chance after having retired from her job. In any event, the rider in clause 6.1.2 regarding income not exceeding rupees 20,000 applies to a person having his or her own business stroke activity. Even without going into the exact quantum of the honorarium stroke income earned by the petitioner, she was otherwise not eligible in view of clause 5.2, by virtue of which she was to apply within 6 months. Although the discretion has been left on the respondent authorities to consider an application, even if filed after the period of 6 months, there has to be some proportionality in the delay occasioned by an applicant and the stipulated time as per the concerned scheme. Clause 5.2 of the concerned scheme clearly envisages that the application under normal circumstances has to be made within 6 months from the date of death. The inordinate delay of 11 years after the demise by no stage of emotion can be said to have any proportionality with the said period as envisaged in the scheme. Thus, the refusal of the respondent is valid on all such scores. In so far, the question of limitation is concerned, the issue which arises here is not limitation in filing the writ application, but the limitation in petitioner applying the first instance for the pension in question. The judgment cited or relied by the parties primarily revolved around the domain of grant of relief under 226 of the Constitution of India, which is not squarely applicable in the present case. In fact, the ratio of the state of Madhya Pradesh and another another versus Bhailal Bhai and others is somewhat applicable in the present circumstances. Since in the present case, the date on which the right of petitioner to claim the pension first accrued was the date of demise of her father on February 18, 1996. After lapse of 3 years thereafter, it cannot be said that the petitioner's claim for quantum of money was valid. The question of, of continuity of the cause of action, which might have alleviated the rigor of limitation, would only arise in the event the petitioner had applied within the time stipulated for a money claim in law. Having not done so, and having waited for her superannuation, the petitioner was not entitled to get the benefit of the freedom fighters pension scheme. On a more basic level, the petitioner was not dependent on her father at the time of his demise and was having an income, thus not being entitled to the pension at the time of father's death. Hence, there is no scope of interference with the refusal of the respondents to pay the family pension to the petitioner under Freedom Fighters Pension Scheme. Accordingly, WPA number such and such is dismissed without any cost. Urgent certified. This is the order. Not here mainly, what the authorities and the court has come to the conclusion there is a time limit to claim pension and there is an income bar. Because if one is in a job, earn something, he will not get. This is the contention. But my contention is from the scheme and thereafter subsequent modification thereafter, I will try my level best to satisfy my lords that there is no limitation for filing the application till 2024. In 2024, limitation had been imposed by 3 years, not for 6 months. If your lordship permits, I have annexed a bunch of documents on the last day. If your lordship kindly takes up that bunch, which starts the first page is dated 15th of August 1972. 2 bunches I have filed. The last bunch is required to be referred.
You applied on the basis of which scheme?
Yes.
You applied on the basis of which scheme?
81 scheme.
In 81 scheme, there is this 6-month limitation is not there.
There was a limitation of 6 months to apply to the bank, not to the authority. After 6 months, I am to apply to the authority. If applied after 6 months, bank will not decide. They will refer the same, or I am to apply directly. So, my lord, kindly bear.
No, show us the order which you challenged in the writ petition. The dismissal of your claim.
Your lordship is impute order to bolo. Impute order bolo.
Page 56 joint commission basis orderটা দিতে
56 order লেখা কথা बताएं 56 এও গেল তাই তো 56 এর অর্ডারটা
But the impugned order in the writ application is at page 56.
50 করে dispose of. That is 7th August 2012.
Yes, sir.
Reiterated on 60. What was it? 60 of the
Initial application.
initial.
And you're subject to correction and your lordship kindly pay to page 45A.
45A.
We'll come back to you.
That is known as application.
That was the first edition, then the 56 is the second edition, which was impugned in the writ application. (45A). 56.
56 যেটা দেখি impugned order 56
56 তো বললাম
2012.
Yes. I refer to my lord.
Yes, you place your case. What do you want to show?
Lord.
What do you want to show? Please tell us.
My lord. Well, I don't know whether my lord, in the hand of my lord, this one is which.
You place your case now. What you are arguing?
Oh, what is my case, my lord?
Page 50.
This is the impugned order.
Page 50.
In the writ application.
Yes.
My lord, my
Please,
case
please place page 57.
57. They have given the reason. In compliance of the above referred court order, your case was examined and the following are the findings. That the power relating to the transfer of dependent family pension is to the eligible dependents of the deceased freedom fighters have been delegated to the concerned pension disbursing authorities, public sector bank or government treasuries, etc. While these ministries later dated such and such dated 1/5/1992. But the audit officers, stroke such and such central author, refused to pay family pension, stating that you have claimed after a lapse of 11 years, as your father, Sri Krishnapada Bera, expired on 18th February 1996. You, however, claimed for family pension on 11th of July 2007. That as per the SS pension scheme 1980, only unmarried and unemployed daughters of the deceased freedom fighters are eligible for family pension. And as per your certificate and DIB report, you were regularly employed from 1979 to 2007 till superannuation. In response to this ministry's letter of even number dated 5/1/2011, asking circumstances not informing about demise of your father delayed or waited 11 years for claiming dependent family pension, you have replied by your letter dated 31st January 2011 that paying bank was informed that when this ministry asked for copy of your letter, you replied vaguely. As stated in paragraph 3.1 and 3.2 above, you were employed as teacher, hence did not claim dependent family pension till superannuation on 31st March 2007 and informed the state treasury only on 11th July 2007. that you are unmarried and unemployed daughter of Sri Krishna Padar Bera. In view of above reason, it is regretted that your claim for sanction of dependent family pension cannot be accepted under the Swatantrata Sainik Samman Pension Scheme 1980. Claim is therefore rejected. This is the impugn order in the writ application.
Yes. Now, what is your argument?
My argument is, first of all, I like to show the schemes where from they are getting the period of limitation. If your lordship kindly takes up the bunch, last I have filed, I have annexed all those documents in that bunch to.
These were not in the writ petition.
Yes, no.
These were not annexures to the writ.
Yes,
Please take your seat.
It is in the annexures.
It is not in the writ petition.
Yes.
Writ petition you annexed.
Paper book page number 25, first annexure. In the bunch, my lordship, I have written also in which paper book.
দেখো তো কোনটা বলছো।
একটু এটা দেখুন না, এইটার মতো। Except in the case of unmarried daughters. Page number 12, Miller. Duration. Except in the case of unmarried daughters, the pension is for the lifetime of the recipient. In the case of unmarried daughters, pension ceases immediately after they are married or become otherwise independent.
Yes.
In the case of death of pensioner, his heirs, though otherwise eligible for pension, will not automatically succeed to such pension. They shall have to apply afresh with the proof of death of the pensioner, and their applications will be considered in terms of the pension scheme. This is the provisions prescribed initially in the scheme. That is, here also, it has not been stated within which time I am to make application. No time period was prescribed.
Except in the case of unmarried daughter, pension is for the lifetime. তারপরে in the case of unmarried daughters, pension cases immediately after they are married or become independent.
Exception to expression to.
One of the note at page 12. But nowhere in the scheme itself prescribed any limitation within which period the spouse or the unmarried daughter is to apply.
Civil
15th of August 1972. Applications received on or before 14th August 1973 will be sanctioned pension from 15th August 72. Applications received thereafter will be considered for pension only from the date of receipt of the application.
That is of the original
Pension. But
so there
from
was no
duration-
limitation. There was no limitation for freedom fighters to apply after 1972.
1972.
Those who apply on prior to 15th August 72, they will automatically be sanctioned upon acceptance, and in those cases where they apply subsequently, they
They
are
will get from
pension
their
pension from the date of receipt.
application.
Yes.
But it is the initial scheme of 1972.
Yes, we
My
understand.
lord, then kindly come to the second.
Then what is your argument? Placing this, what is your argument?
There is no limitation for the spouse or the dependent unmarried daughter for claiming freedom fighters.
No, where do you get this spouse and freedom fighter?
In the duration period? In the duration period, no limitation has been prescribed in 72 scheme. This is the initial scheme.
Read the first line, duration, except.
Yes. Rather, I am reading from the last portion of the third line. In the case of death of a pensioner, his heirs, though otherwise eligible for pension, will not automatically succeed to such a pension. They shall have to apply afresh with proof of death of the pensioner, and their application will be considered in terms of the pension scheme. So, within which time after the death I am to apply, that has not been prescribed. My argument is to that effect only. But this is the initial scheme of 1972. Now the 1981 scheme came on 15th of August 1981. Your lordship will find
70.
page 13 starts the scheme. I will refer, my lord, at page 18.
So this which you page 12 you showed us is 15th of August.
That is the initial scheme of freedom fighters.
Don't repeat, we are asking.
Sorry, my lord.
15th August was the original scheme.
Lordship,
15th August is the original scheme.
Original.
Please, Mr. Manna, don't repeat. Please proceed. If we have any query, we will ask. Yes. So page 12 is 15th August 1972 scheme. Very good.
And
yes.
My submission is in that scheme.
We understood. Next.
Then your lordship kindly come to page number 13 of the bunch. Subsequently, that scheme was renamed as Swatantrata Sainik Samman Pension Scheme 1980, which came into force on 15th of August 1981.
Yes.
No, I will not make
Please continue. Please continue. Yes.
Well, I am referring.
Please.
Paragraph 12 at page 18.
Page
18. 1-8. Of the 81 scheme.
Yes.
Here also, Miller, I am reading. It is the same word as of 72.
That is as of page 12.
As of page 12. Miller, I am reading it. Except in the case of unmarried daughters.
You don't have to read. This you are saying same as 12.
12. So, here also,
there was no limitation for very
applies. Then, my lord, your lordship kindly come to page number 20 for a moment.
Page 20.
20.
Yes.
Paragraph 1B.
What is page 20?
Page 20 is simplification of procedure of transfer of pension. You will also will find at page 19. scheme for payment of freedom fighters pension with effect of 1190, simplification of the procedure.
Yes.
By this, Lord, the procedure has been simplified. Lord, I take my Lord to paragraph 1B.
Paragraph 1B.
1B at page 20.
Yes.
Where the pension has been sanctioned to the freedom fighter on or after 90, and the freedom fighter has since expired before or after drawing the pension for some period, and where name of the spouse was not included in the sanctioned letter stroke PPO, the Freedom Fighters Division, Ministry of Home Affairs shall, on receipt of a request from the spouse, unmarried daughter, unmarried dependent daughters, call for his or her verification report from the district magistrate concerned. After receipt of verification report, such cases will be proceeded as phase 1, and necessary sanction addressed to the Chief Controller of Accounts, Ministry of Home Affairs, is issuing phase PPOs.
Yes.
Then Miller paragraph C also.
Paragraph
C at page 20. 1C. Where?
When was the pension sanctioned to your father?
My father's pension was sanctioned prior 90. Prior 90.
Yes. What you want to show? Clause C.
So I am referring
where pension has been had, the freedom fighter has since expired, and where the name of this was not included, the freedom fighter shall, on receipt of request, call for his verification. After
verification. That is of the B. Then kindly come to C, where the pension has been sanctioned to the freedom fighter before 1190. In my case, my father was granted pension long before that, and the freedom fighter has since expired before or after drawing the pension for some period, and where the name of the spouse was not included in the sanction letter stroke PPO. In my case also, my name was not. The Freedom Fighters Division, Ministry of Home Affairs shall, on receipt of a request from the spouse, unmarried dependent daughters, call for his or her verification report from the district magistrate concerned. After receipt of the verification report, such cases will be proceeded as a phase 1, and necessary sanction addressed to the Chief Controller of Accounts, Ministry of Home Affairs, for issuing of phase PPOs. In such cases, the old sanctioned PPOs will have to be cancelled. But here also, no period was prescribed for applying by the spouse or the unmarried daughter. After my application, they will proceed.
Yes.
Lordship, kindly come to page 24. Next circular. This is circular of 1st May 1992. It was further
page 24. Page 24.
24, Milord. It starts. It is dated, Milord, 1st of May 1992. Milord, I will draw my Lord's kind attention to paragraph 1.1b Roman I. That at page 24, last paragraph.
Yes.
In case of pensioners already drawing their pension through the public sector bank, Director of Accounts, Treasury, Pay and Accounts Officer, payment of family pension as indicated in the pension payment order shall be commenced by the disbursing officer on receipt of death certificate and application for family pension in the prescribed form along with petitioner's portion of the pension payment order. The disbursing officer will enter the date of death of the pensioner in the disbursal portion of the pension payment order and also make an entries in the pensioner's portion of the pension payment order before commencing payment of family pension, or disbursing officer will take action identically. So here also
No limitation.
no limitation.
Yes.
I should place also paragraph 1.1 BII. In cases where nomination does not exist, here also in my case there is no nomination. No nomination does not exist. The disbursing officer may make payment of family pension after obtaining an affidavit affirming the dependent relation to the freedom fighter. A passport-size photograph of the dependent of the freedom fighter should be affixed on the affidavit, which may also be duly his official seal. So, my lord, here also I will say, my lord, there is no limitation.
No, can you give us the date when pension was sanctioned in favor of your father? Ask
I
your
can.
junior to find out. Yes, next.
My lord, give
1977. 7th August 1977.
input order আছে দেখো না, input order থাকতে পারে।
তাহলে
Well, I am giving that date.
সেইটা 1970
দেখো না কোথায় আছে। So, sorry, minute.
Now page
26.
Page 26.
26. It is dated, my lord, 13th of October 2000. Further clarifications. My lord, I am referring the paragraph 2 Roman II, Roman 2. The claimant of family pension should fulfill two conditions of falling into the eligible category of relationship, that is widow or widower, unmarried daughters, mother, father, or their dependents.
Got it.
Then, my lord, 26. My lord, I will then take my lord's to my lord page number 168 of the paper book. My lord, that was a bulky, I could not annex. 168.
Last line of that paragraph. Last line of that paragraph.
You will get your chance, Mr. Bhattacharya. We are not running away.
No.
168, my lord. 168.
168.
8 of the main paper book, not supplementary. And if your lordship takes the supplementary paper book, then it is paragraph page 35. Better your lordship take the original paper book. It has been twice.
Page 168. Yes, 168. This is
paper book. My lord, I am
is
referring to the paragraph.
This is a guidelines for disbursement.
To the public sector bank.
This is what is the date of this?
Your lordship, can you have a look to the nomenclature of the scheme? My lord, it is, your lordship will find
Page 61, 62.
Page 161.
Guide.
This is the subject, revised policy guideline for disbursement of central Samman pension to be followed by authorized public sector bank.
এই ইয়েতে ডিসমিস করলো ওইটাতে ও এইটা
This circular was in the judgment of my lord sitting with my lord Justice Matre held.
Page 161. Yes.
61 the scheme initially, though my lords have held that this circular is not applicable because this is neither a guideline nor a amendment to the scheme. And it has been held by my lord sitting with my lord Justice Matre and also my lord Justice Mila Bhattacharya. It has been held in other cases, not in this case. However, my lord, without going to that effect, I would like to refer, my lord, paragraph 5.2 at page 68. 168. After the sorry.
Page 168.
I am reading that one. After the death of the pensioner, where the freedom fighter himself or his spouse, the transfer of pension to the spouse daughter will only be considered if she applies for transfer of pension within 6 months of the death. Here, first limitation was imposed. What it says, prayer for transfer of the pension by the spouse or the daughter is to be made before the disbursing bank within a period of 6 months. That is the limitation prescribed.
Yes.
The application receipt after 6 months shall not be considered by the bank, but refer to the ministry. The ministry shall then take a view.
Yes.
Whether to allow dependent pension or not, or whether any arrears are to be paid. This is the question. Though it has been categorically held, this cannot be accepted. This limitation cannot be prescribed by the division bench of the other judgment. I will refer to later on. Let me place the scheme first. Then, my lord, your lordship kindly come to paragraph 5.2.2. 5.2.2 at page 169.
146 nomination
of the paper book.
Page 146.
Now, while he was living, second paragraph, he nominated Srimati Sadhana Bera, unmarried daughter, to enjoy family.
It is your first.
Six months, if application received by the bank, that will be forwarded to the authority concerned. Now, your lordship kindly have a look to paragraph 5.2.2 at page 169. Taking into consideration that if any application for transfer of the pension by the spouse or the daughter be made after the period of expiry of 6 months,
Please
then
answer one question of ours. What is the admitted fact? Admitted fact is the pensioner died in 1996.
Yes.
At that time, you were doing a job, but
Yes.
you were getting less than 20,000.
Yes.
You should have approached the court immediately after 1996, or you should have made a representation to them saying that though I am engaged, but it is Gandhi ashram getting less than 20,000. What prevented you from making an application at that juncture?
I can understand. Your lordship will kindly consider that bar came in 2014.
Forget about the bar,
That limitation of income. Initially,
we are not asking that. We are asking you that you did not apply. Why? Because you
I
were
was in employment.
You were in employment. Now you are coming to us and saying that that employment would also not be a bar because I used to earn a paltry amount lesser than 20. Then why didn't you say this thing to the authority in 1996 itself?
Correctly, madam.
Why?
I understood.
Please answer up. When you understand.
I'm answering.
Yes, yes.
In the scheme,
forget about the scheme. We are asking you that in Mr. You
reply,
are
I
not
have to-
answering the query of the court, Mr. Manna.
I applied.
You will place your case. We will want your answer. When in 1996 your father died, your income was less than 20,000. Because that is the plea you are
that
taking.
was not prescribed in the scheme. It has come later on.
Maybe,
The limitation
maybe,
of
but your conduct is there, na?
No,
You consciously did not apply.
no, Miller, because scheme says unemployed. Unemployed means a person who income earns 100. He also employed. A person who earns 1 lakh per month.
Exactly. Exactly.
Scheme
When
says unmarried and unemployed. That was the scheme. So as I was employed at the time, I could not. Subsequently, considering the effect, government has modified. No, that cannot be. There should be an uniform guideline which has come into force in 2014 first, then 15, then 16. It is clarified.
Then why didn't you say that? That in the scheme there was no such cap. But this scheme which came later on will not be applicable upon me. Please consider my application.
Your Lordship know my capability.
I tried to through which window we will enter, Taylor.
I tried to.
You are trying your best. You are trying your best, Manna. You are also veteran in this. You are also veteran in this. We are saying that your argument is 2014 the new guideline came.
Yes.
There was no specification of limitation earlier. When it came in 2014, you were also not aware in 1996 whether any such cap will occur subsequently.
Yes.
Then what prevented you from applying? That the word is unemployed and you cannot treat my engagement in Gandhi Ashram to be an employment in the truest sense of things. Please consider.
I followed. My submission will be as I was earning something.
No, Mr. Manna,
But
then your argument false. Your argument before us is what? As we have understood, that my lord, kindly see, 1996 my father died. At that time and the previous scheme, nowhere we will find that an unmarried daughter has to apply within 6 months. There was no limitation. But why didn't I apply? I applied in 2007 because I was in an employment. Now your argument is self-destructive. You are saying that even if I was in employment, that cannot in the truest thing can be construed to be an employment also. You are a daily wage earner, getting 50 rupees per day. Will that come under the fold of employment? You could have made that argument, but you did not. Court proceeded, Mr. Manna. How can we help you?
Because my argument is to that effect, because initially what happened, when a person was earning a few money, their application was not allowed because they are in employment. Subsequently, considering that government has revised the scheme, government has revised of the paper book.
Page 42.
42 of the paper book.
42.
Where I have stated 42.
Your application?
Yes, my lord. My application.
My
lord, the second paragraph. Actually, third and fourth paragraph. In 2007, I have stated while he was living, he nominated No, এটা না,
Terminated
application, sorry, মানে 42. Sorry, মানে 42. 42.
42
While he was-
Sadhana's application.
এটা সাধনা বেড়া। The freedom fighters pension was sanctioned in favor of my father, late Krishnapada Bera, by PP number Ato, and he enjoyed the monthly pension up to January 96, as he died on after 18th of February 1996, on the afternoon of 18th February 96. While he was living, he nominated Srimati Sadhana Bera, unmarried daughter, to enjoy family pension after his death, and the said nomination was accepted by the Director of Audit and Central Calcutta by number pension audit number such and such, dated 16th of November 1985. After the death of my father on 18th February 96, I prayed to the paying bank to pay money for month. I was nominated by my father.
No, you indicated, but before Justice Jayanto Biswas, you said let them consider in terms of the scheme. Where that 6 months and 20,000 was.
No, then 6 months was not.
Order
6
of-
months came in 14.
Yes.
In 14. 2014 guideline, 6 months came. And thereafter,
When was the order of Justice Jayanto Biswas? 23.
23.
এটা আসছে না, কিন্তু এটা তো থেকে যাচ্ছে না।
না, Joseph, 52. One 69.
Yes, what do you want to show?
168, then Miller, I refer 168, 169, paragraph 5.2.2.
Yes.
First, the dependent pension shall be paid from the date of application by spouse, daughter, and not from the date of death of pensioner. But considering this effect, that if the dependent of the freedom fighter do not apply within the period of 6 months or within immediately after the death of the father, then what will happen? The authority is concerned, thought about the issue. So this paragraph has been incorporated that if not applied earlier, their pension will be sanctioned from the date of the application. Thereby, he or she will be deprived of the pension from the date to the date of the application. Thereby, they have been penalized.
Yes. Yes.
Then Miller kindly take up paragraph 5.2.3 at the same page, 169. The spouse, daughter must fulfill twin condition of being unmarried and having no independent source of income. They have to submit 2 certificates as per Annexure 6 and Annexure 7 to the bank. Then we will kindly skip over to page number 170, paragraph 6.1.2.
Yes.
The bank must ensure that a dependent pension is not sanctioned to a spouse or daughter of a freedom fighter if the spouse daughter is already employed in a central or state government, central, state, PSU or local body. In case the
168 is 168, 5.3. 5.3. Transfer of pension to spouse.
ঠিক আছে, এখানে আমরা তাহলে 6.1.2 clause will apply in cases where it is applied within 6 months. Yes, Mr.
well, then paragraph Roman 2. In case the spouse daughter is working in a private sector or having his or her own business activity, then income from such job activity exceeds rupees 20,000 per month. That is, if I earn more than 20,000, I will not get. This was the prescribed in 14. Then we will kindly come to page number
Private sector.
it was just page number. Then I will take trouble to my lord to the paper supplementary paper book, page 85 or page 29 of the bunch.
6.1.21
already named
central or state government, PSU or local body. সেখানে 20,000 এর ক্যাপটা দিল।
It is more than right.
কেন
না না, ওরা বলছে ও যদি অ্যাপ্লিকেশন
has been amended, as your lordship will find at page 29 or my lord supplementary paper book, page number 85. It has been annexed in the supplementary paper book. I have been annexing the bunch at page 29.
of this bunch.
Yes, yes, this bunch, page 29.
Yes.
Lord, your lordship kindly come to page 30 of the bunch. Explanation 1.
Clause?
No, clause explanation 1.
Achha, explanation.
As a thumb of rule, as a thumb of rule, if a spouse daughter is already receiving one salary pension excluding the state freedom fighters pension, either due to his or her own job, or this is father's, mother's, this is husband's, father's, mother's previous job, then such spouse daughter should not be sanctioned central pension, freedom fighters pension. Thus, as per paragraph 6.1.2 of the revised policy guideline, the upper ceiling of monthly income was not uniform for government or private source of income. To remove the above anomaly, the matter has been considered in consultation with Department of Expenditure, Ministry of Finance, Government of India, and it has now been decided to amend the said paragraph 6.1.2 of the revised policy guideline by introducing a uniform income limit of 20,000 per month or 2,40,000 per year, irrespective of whether it is from government or a private source. Accordingly, paragraph 6.1.2 of the revised policy guideline will now be read as follows. My lord, that is, my lord, paragraph 6.2 is good. The bank must ensure that the dependent pension is not sanctioned to a spouse or a daughter of the freedom fighter if
Yes.
if
How does
the-
this help you? How does this help you?
let me compliment, it will help because my case is there was
All right,
legal meeting.
please continue. Please continue.
Well, I am trying my level
Please
best for the
continue.
sake of my client.
We are also trying our level best
Yeah,
to
to
continue
give
hearing.
relief to the client. I understand.
Please, please
Let me
continue.
clear myself. Now, the spouse and daughter is already employed in central or state government, such and such, the local body. The income from such local activity exceeds rupees 2,40,000 per year or 20,000. It has clarified that. Now, kindly come to paragraph 4 of that page. It is therefore requested to issue instructions.
Yes.
To issue instruction to all concerned to follow these instructions scrupulously and take certificate from the dependent of the freedom fighter about amount and his or her source of income at the time of transferring of pension and also at the time of taking life certificate annually. All the banks are directed to review, reconsider all those cases in which pension had been stopped on the ground of multiple pensions received by the dependent spouse, daughter, keeping in view the above income ceiling limit as per year such and such. So even if that was rejected, that was directed to be reconsidered, then we are last paragraph at page 5 at page 31. These cases, the cases in which the monthly annual income is above the upper limit prescribed above, may be reported to the ministry along with a notice, intimation to the pensioner that to be indicated to in the notice of it, the pension may be discontinued in view of such and such. So, my lord, it has been prescribed in this circular that in the cases where the application has
been understood.
Your Lordship has. I will not.
Anything else, Mr. Manu?
I got 2-3 documents more. Your Lordship, kindly come to page number 32 for a moment of the bunch.
Yes.
Well, I need not read the upper portion of this page, but I will only refer to, my lord, comments of Freedom Fighters Division. The last paragraph. As per above mentioned, well, there are some notification was referred which has been, my lord, shown to my lord. My lord, as per the above mentioned office memo, all the banks were directed to review, reconsider all those cases in which pension had been stopped on the ground of multiple pension received by the dependent pension spouse, daughter, keeping in view the above income ceiling, and if found eligible, the pension may be released with immediate effect.
Yes.
So, in the case of where it has been rejected on that ground, that is to be reviewed. Now, your Lordship, kindly come to the circular of February 23rd, 2013. Again, it has been clarified at page number 34 of the branch.
Yes.
My lord, I referred already, my lord, in the first paragraph as per memo dated 15th, I have already referred at page 29. I need not refer again. In paragraph 2 also, my lord, the office memo dated, my lord, 3rd of March 2016, I have referred at page number 32. Now, your Lordship, kindly come to paragraph 3 of that page. As regards the release disbursement of arrears, it has now been decided in consultation with the Department of Expenditure that the stoppage of pension of the spouse daughter may be released from the date in which stopped on the ground of multiple pension and such and such. Then the further lastly, regarding a limitation, my lord, I have submitted before Lordship nowhere in the scheme or the guideline as the limitation for filing the application was prescribed. My lord, it has been prescribed in 2024, dated 10th of October 2024, at page 36.
No, this 6 months rider came on the basis of page.
But I could not follow them.
23rd December.
Page 36 of the branch, my lord.
6 months time, page 168.
Okay, body
2014 গাইডলাইনটা 2014 Yes.
The paragraph 2, the policy guideline for the scheme was last revised in 2014. The revised policy guidelines were issued on 6th of August 2014, which is available on the ministry's website number. However, but I am pressing this. However, considering the difficulties faced by the beneficiaries under the scheme, the revised policy guideline 2014 are amended hereunder. However, I will not take much trouble to my lord, the paragraph T of at page 37. Right hand side. The original was in the left side and the amendment at the right hand side.
So this was not in
6 months has been extended.
No, this was not before the writ court.
This was not before the writ court because it is on 24th count. But it's October.
Which paragraph you are showing?
My lord, so I like to say before, show my lord paragraph 4, right hand side. Para 5.2. After the date
So
of
6 months to 1 year.
1 year. Now, about the limitation for filing of the application by the dependent. Your Lordship, kindly come to page number 39, paragraph 4, Roman 2. Roman 2.
This goes against
the claim. No, it does not go against me. I am coming. It is in my favor. The claim of those spouse and unmarried and unemployed daughter for dependent pension will be considered only if it is applied within 3 years of the death of the original pension. Yes. if it would have been come in the retrospective way, it is against me. But it is not retrospective, it is prospective. Then the above amendment, paragraph 5, the above amendment shall come into force for all the applications received on or after the date of issuance of this order. So this limitation of 3 years will be applicable in respect of the application received after this application, this circular or this amendment.
Yes.
So, my lord, by placing this, I intend to submit before lordship. Prior to, as it has been prescribed 3 years only, prior to that, there was no limitation for filing application for dependent pension. Now, in a similar matter, in a just identical matter, in the case of my lord Oloka Bera, his father died on 31st March.
Where you are showing? Where
at page 40.
This is 40 is another circular. 24.
Another matter. I am referring in identical matter. Here, the lady was, the daughter was Oloka Bera. His father died on 31st of March 1980. It will be evident from the letter itself. She did not apply till 2007 without applying made a writ application before this court, wherein this honorable court, disposing of the application, directed the authority concerned to consider, dispose of and consider the matter in accordance with law. Upon considering, they have granted.
Where did you place it before the writ court?
This judgment was not. Frankly speaking, Miller, it was with the respondents. They complied with this by complying with the order of.
Where is that? Show us.
Miller, your lordship, kindly see. Miller, I am reading, your lordship. The case of the prisoner, Mr. Oloka Bera, who is the daughter of late Sri Hare Krishna Bera, the petitioner's father was sanctioned pension with effect from 1/8/1980. Void sanction letter number dated datum. Sri Hare Krishna Bera died on 31st March 1980 without receiving any pension. The mother of the petitioner died earlier. The petitioner filed WP number such and such of 2007 for releasing the family pension in her favor on the basis of his father's sanctioned pension. The Honorable Court, High Court, Calcutta, in its order dated 23rd April 2008, in this petition number also has directed as under. I have heard the learned advocate appearing for the petitioner, and after considering the facts of the case, I direct the respondent authorities to consider the case of the petitioner by treating the writ petitioner as a representation and dispose of the same by passing a reasoned order after giving an opportunity of being heard to the petitioner within a period of 6 weeks from the date of communication. Then, in this matter, they never applied. They filed a writ application. This court directed to consider this is a representation. So, this is to be treated as a representation of 2007. Father died 80, 2007, after 27 years. They consider and allowed the pension.
Father died without getting pension. Father died. He did not receive any pension.
That is not the extra point.
Paragraph 1.
That is correct. Father did not get. If get, would have been get.
Here you have got
right
from 1996 to 2000. You have got prior to your sanction was 72.
Yes.
You got enjoyed it till 1996.
My father enjoyed till 96.
In this case, he did not get.
I am on the point of the daughter only. Here the daughter did not apply after the death of the
so
father.
Factually it is different.
That's not a point here, Miller. Well, my point is date of application. For the unmarried daughters.
Next anything.
And thereafter they sanctioned and paid, complied with. So here also the authority concerned did not consider the application had been done after 20 years. If the limitation was there for claiming the daughter's pension, they could have rejected, but they allowed because there is no limitation.
Paragraph 4.
Because this cannot be filed, issue was a subsequent sanction.
The petitioner being unmet daughter getting the pension.
আরে এটা তো স্যাংশন অর্ডার
এই ক্ষেত্রে ও পেনশন দিয়ে দিয়েছিল ওকে। What is paragraph 4? Page 41.
Page 41, paragraph 4.
This is one.
The honorable court passed the order on that is the when they were not giving a writ application.
Died in 80.
80.
And you applied?
I never applied.
Aloka Beda did not.
Never applied. Filed a writ application without even making any application. That writ application was disposed of, directing to treat the same as an application. My argument is.
Then what did the court say? Then what did the authority say? Page 4, paragraph 4.
Paragraph 4. Takali, allow me 1 second. The same was not done. A writ application was made. In the writ application, second writ application of that person, lady, this order was passed. The honorable court passed the order dated 22nd July 22 in WP number such as such. The order of the judgment reported as follows. This is the order of the court.
Report filed on behalf of
আমাদের judgment এইটাই নাকি এই judgment কি
petitioner
judgment কার
was getting
is wrong. This is not. He died in 80.
unmarried daughter did not get the pension.
No.
But it is reported in
There is a typographical mistake. That's maybe I can bring the judgment, give the judgment. Father died before Miller getting the sanction order.
Kindly read that.
So,
BLR further certifies that petitioner is an unmarried daughter and legal heir of her father.
Who was
Father was a
the pension?
But now kindly come to paragraph 1.
Paragraph 1.
Aloka Beda is daughter, petitioner's father sanctioned pension, vide such and such, but he died without receiving pension.
Without receiving, before receiving the sanction order. He died. He kept mum, did nothing. 2007 writ application, directed to consider. In considering that same, nothing was done. Then writ application says that he passed this order. The sanction was made with effect from the DM's order report. Then writ application again moved as to whether it is she is entitled to have the pension from the date of her application or from the date of the report. In the report, the order has been, corrigendum has been issued and sanction order has been given from the date of death of the father. From the date of the application. Sorry, Miller, I am sorry. From the date of the application, that is 2007, your lordship will find the corrigendum at 44.
The father died in 31st March 80.
80. His application was directed, his writ application was directed to be treated as on 2007. That representation, when as the
way that representation was rejected on 18th August 2009, page 40, last line.
Page 40, last line. Page 40, last line. Yes.
Deputy Secretary rejected it.
Yes, Miller.
That order is not with us.
Another writ application was moved.
So in the next writ petition, paragraph 4 says that
yes,
she was receiving pension, unmarried daughter. Anyway, then subsequently again said consider afresh. Now place paragraph 7.
Paragraph 7.
In compliance
in
of
compliance with the order dated, it is stated that there is neither any willful delay on the part of the Union of India nor any provisions to grant any interest in SSS Jojana. Accordingly, I am directed to convey the sanction of the President for grant of Swatantrata Sainik Samman dependent pension under the Swatantrata Sainik Samman Jojana at the rate of basic pension rupees per month plus DA.
Your argument is in this
with
case
effect from 2016. It was sanctioned.
2006, yes.
Section. Then it was challenged.
I see.
Because I am not entitled to have the pension from the date 16th. That is the date of report of the DM. I am entitled to have
from
the
date of death.
No.
Application. Date of application.
Date of application.
Where is
2007. Then, Milord, writ application was directed, disposed of. Considering that, Milord, that order has been, Milord, annexed. Annexed to the
page 49.
No, 49. Milord,
page 49.
Another writ application was moved.
Understood. What is the final order? Giving effect from?
Milord, she kindly take pen up, which I referred on earlier occasion at page 2015.
In view of the above,
it starts from Milord 200, Milord.
200.
Paper book 210.
Because there is
main paper book. It is supplementary one.
Main paper book
210. My lord, all okay, beta, my lord, find at the top. This was challenge. So, beta, देखते बोलिए.
Page 250. 150. Para 17.
And in para 17, this court directed to pay the same from the date of the application is 2007.
Yes.
So, this very court who has rejected the application of the instant appeal has passed the same order. Because that court.
Yes.
And similarly, in another case, also in other court, where father died, I have annexed that judgment after.
Don't cite documents which are not in the writ.
It is a judgment, not the documents. No, which I have got subsequent.
Which one you are saying?
Compilation last.
Page number 48. here your lordship will find well, your lordship will take
Page 50.
page 48. This is the application of the unmarried daughter. The application was 16th of December 2016, wherein father died in 93. Died 93, apply on 16th of December 16, and then Miller sanction order has been passed in 22. This was done, nothing was done. Then Miller writ petition was moved. In the writ petition, direction was given. They have complied with and paid the amount from the date of the application. Here also Miller 93 and 16, more than my period. Application is 48, report as 49, course order as 50. Yes. And Miller, on the basis of that, Miller, when a writ application was passed, disposed of, on the basis of the order, sanction has been effected.
Thank you, Mr. Manda. Yes. Mr. Bhattacharya, come back at 2 p.m.
Miller, one thing I could remind, the judgment which has been deferred by the learned additional Solicitor General before the trial court, the Bhailal Bhai's case,
That is 64 limitation.
That
has been overruled by the Supreme Court.
In 1997.
In 1997, it has been overruled.
Show us that, give us that.
My subject to your lordship kind sanction, may I submit one thing? Well, I have prepared for my own manner a list of notes of argument. And so many documents has relied on. So, my lord, should I come back, my lord, your lordship?
2 o'clock.
2 o'clock, as your lordship.
At 2 o'clock, shall I bring that judgment?
Yes,
Final-
sir.
Well, I'm sorry, Miller, to disturb for a long time, Miller. I'm sorry. Because, Miller,
None. What? You are doing your case, you are doing your duty.
I am to try my level.
So, Mr. Why didn't you show that order to my lord? Oloka Bera, why didn't you show this order? You appeared in Oloka Bera. তাহলে?
That has come later on.
হ্যাঁ?
That has come later on. Last order is come later on.
No, not Oloka Bera.
That too. But apart from that,
Apart from, why didn't you place that to the learned single judge? Then, my lord, you have passed an order in which there was a delay of more than 10 years.
but that has been, yes, I have not placed that for some reason. Subsequent to the impugned order,
Yes.
that court has passed. I have referred that letter. Or in the case of the Kanchan Burman case.
Mr. Manna, in both the cases, the issue was as regards limitation, not as regards unmarried daughter or employment.
Limitation.
You have as regards unmarried daughter, you have made your submission, and limitation you have made submission. Those two cases are not exactly the same. Not exactly the same. But when his lordship in such matter has exercised discretion, you should have placed that before Justice Ban.
Not only in that case, subsequent to the order appealed against, his lordship has ignored the delay. But in the Kanchan Burman case, which I referred on the last occasion, your lordship will find that another bunch, when I headed by the
Mr.
submission on
Bhattacharya,
behalf of the appellant.
Mr. Bhattacharya,
Well, I have given the copy, bunch objection. Well, kindly allow me to give two judgments.
this is a case. Why should we not send it back for remand consideration?
This need not be honored. I shall submit to your lordship. But the case made out in the writ petition and the case made out in the appeal is completely different. But a third case cannot be made out before the appellate court, and the top of it, the conduct of the petitioner. She has not disclosed. For the purpose of limitation, she is relying on.
Bhattacharya, are you ready today to distinguish that order?
To that order, I am on merits of the what is in the
No,
paper.
you please take instruction. We are not.
That is,
We,
whether the facts of that case is just applicable in the facts of the present case, that is a point.
Yes.
Oloka Bera's case.
So for that, you need to go through the judge.
That's true. That is.
So if we find if we are just interacting, we are not saying anything.
Grateful.
Suppose he has a bad case, but the thing is that when the government has, as regards the delay, when the government has taken a decision, this decision ought to have been placed by him.
What is passing through your lordship's mind, I have understood. But fact is whether these facts are similar to that is applicable or not.
So you please check up that. You
Check
please
up
check up that and then come, because
Then I have followed what is passing your lordship's mind. That even your lordship will remand the matter for
we
reconciliation.
are only interacting with you.
No,
We are
that
not
is- that is
sending
fine.
it.
And so far the other point, I am otherwise ready, my lord. So far this is concerned.
Which is the other order you are showing?
My lord, your lordship got the other bunch of the
Yes.
headed by submission on behalf of the appellant.
দেখো তো এটা সাহেবের
তুমি ওইটা আমাকে দাও।
কোনটা দিয়েছি বাবু আগে?
অলোকা বেরাটা তো দিয়েছো।
আরে এই একটা বাঁশ দিয়েছি।
এই 15th
না, এটা না, আরেকটা বাঁশ আছে। Lord, your lordship, kindly come to page 8.
এইটা
Show Mr. Bhattacharya first.
না এটা নয়, আরেকটা দাও। Take it, যদি না পাবে আরেকটা দাও। He is saying that he is not available.
No,
Why?
he has to find it out.
No,
Please find it. If
No,
he has
the third
I am
copy of
giving the third copy. No problem, my lord. I got the enough copy.
yes, what you are showing?
My lord, your lordship, kindly come to page number 8 for a moment of the judgment of the division bench judgment of my lord Madras High Court. Where it has been held, I am referring page number paragraph 4 at page 8. It is to be noted that grant of freedom fighter pension is as per the scheme formulated by the government, which has a statutory force, and the entitlement pension is as per the scheme. Merely because the petitioner is receiving a small honorarium sanctioned by the state government on account of having become widow at the young age, cannot be ground to reject the petitioner's application for family pension under the Freedom Fighters Pension Scheme. Then we will kindly come to paragraph 5 for a moment. So the amount which has been paid by the government to the
So paragraph 5, in my view, they should. Paragraph 5, in my view, they should.
Yes, Lord. In the Madhuri case, where the request for granting freedom fighters pension was rejected on the ground of application, there was receiving civil service pension and there is not entitlement for true pension. The Madurai bench of this court in the above circumstances stated was the said order and directed the payment of freedom fighter pension in addition to the service pension. So payment, receiving of some pension or some amount of salary or honorarium is not a bar. To that effect, I am referring this judgment.
No, this order was passed considering your 2014 guideline.
2014 judgment, I don't remember that.
Not judgment, guideline.
The judgment is of
1915. Judgment is delivered on 2015. By that time, the guidelines came.
14 guidelines has. Well, I am coming to that. I am coming to that of the judgment of this court. I am coming to
judgment.
If your lordships kindly come to another judgment of this court at page number.
No,
13.
you answered our query na. In the order which you have shown, Madras High Court, was 2014 guideline taken into consideration?
Because there was the honorarium was receiving. The rejecting.
So it was not taken into consideration.
That is not written.
Just referring to my lord.
Understood here.
Basement to accept.
You should have placed these matters before the single judge. You only appeared. God knows why didn't you place?
In the last judgment, what I
would have made an application, give me a supplementary evidence placing these records. Finished. Court would have dealt with. They will be taking that point, and that is a justified ground. How did he start? That please don't go beyond what is there in the writ petition.
My case was rejected first. Thereafter, second case.
Then there will be no end of litigation.
No. In the what judgment I like to
all right, you finish off.
Refer, my lord, at page number 14. Page number 14 of this month.
Yes.
Here, the application was made beyond the period of 6 months. Beyond the period of 6 months. But this is by the same judge as of the impugn order.
Yes, in this matter, the death was in February 2018. The application was on August 30th, 2018. In the one you're relying upon.
Yes, there are only 2 days. That's not what the finding. What the finding is. If your lordships kindly come to page 13 for a moment.
Why should we come to 30?
Page, paragraph 16, page 13 of the bunch. What the law has been formulated by the court.
Paragraph?
Page 17, my lord. Paragraph 17. Page 17, paragraph 17. A perusal of the revised guideline, which have also been relied on by the division bench of Delhi High Court, shows that the same as rightly contended by the learned counsel for the petitioner, were merely guidelines issued to authorize public sector banks by the Ministry of Home Affairs for disbursement of central pension. It has rightly been contended by the petitioner that the said guideline issued subsequent to the scheme by the concerned ministry to the authorized public sector bank do not form a corrigendum or an amendment to the original pension scheme, which still remains intact. In fact, the modalities as stipulated in the said guidelines can at least be pertain to procedural nuance of the disbursal under the scheme and cannot affect any substantive right conferred upon a person under the scheme. Read in conjunction with the
How this is applicable, Mr. What my
Because it is
brother asked
applicable
me.
in the sense, in the delay.
This delay was not the issue. But try to
The
understand.
issue, Mr. Manna, in this matter, the issue was whether the pension would be payable from the date of demise or from the date of the application. That was the issue. How does this help you?
It is settled by the law. It is from the date of the application, not from the date of the death.
Already.
I am not claiming from the date of death.
The conduct,
you
limitation,
Has been
income.
held
check those two judgments.
that as soon as
that
I
these
applied,
distinction points
my
appraisal,
right accrued.
কি ওর
Order ছিল।
Any day after my 10th of this month, November, because I will be out of station for my personal count. 11th, 12th, any date.
November. আমরা ফিরছি কবে? Well, in that case, we will make sure the lordship after 14th, I will be out of station. From 9th to 14th, with the others.
তুই প্রফেশনাল কাজে যাবে, আমি পার্সোনাল কাজে
না না
is condoned, whether in the facts of the present case.
Correct. You are saying that 1964 judgment?
Yes, my lord. That is what we regard to
Has been
the.
overruled.
It was referred by my learned friend before the trial court.
That is a state of Madhya Pradesh
Bhailal,
versus Bhailal.
versus Bhailal Bhai's case.
Ota-
That has been overruled in 1997, 5 SCC by the Supreme Court. At page 536.
Overruled 1964. This is not correct.
কি
Subject to correction.
ভালো কথা তুমি দেখাবে আমি বললাম আমি তো যেটুকু পেয়েছি ভাই
Very good. It is understood. You have nothing more to say. We will only hear him and
Yes.
trust him.
I have whatever I have submitted I have written in the notes of submission.
পরের দিন এসে আবার
The bundle, second bundle, submission on behalf of the appellant. I have given the gist. I have tried my level best to assist my lord, my lord.
18
Every time I do forget, so I have written what I have submitted.
and there is a now there has been a resolution of 330.
এখানে এইটা একটু
Matter, my lord, I am appealing for the appellant.
You are for the appellant?
Yes, sir.
Yes, tell us what is the matter.
Private unaided school was directed to pay all the areas and all the service benefits of the writ petitioner respondent herein. We are taking the preliminary point regarding the mandate of the writ petition against the unaided private school regarding the service matter.
What happened?
My lord, I am the respondent number 1. My lord, on the earlier occasion, my lord, I comply the order. My lord, earlier the applicant is not appeared. My lord, I serviced him on the by the basis of the last order.
Very good. Now who is leading you?
Mr. Abhimanyu Banerjee.
Where is he?
Obimunnu Banerjee.
And these affidavits have been extended.
Only
No.
reply we have to file to.
You have got a copy of the reply
Yes.
No,
Sir, the Joshua বলছে পাইনি।
no, my lord.
just now.
My lord.
Reply copy দাওনি? Yes, how?
18th August.
নিয়ে নাও।
18th August we have served.
man.
Hmm.
Every bit of service.
No, in this matter, I'm appearing on behalf of the respondent read petitioner.
So assign matter.
Assign.
Assign.
It was earlier occasion it was released due to some personal
Released by whom?
by my lord Justice Sain.
The order was passed by the single coordinated bench, the single bench. My lord, that the honorable judges of the cooperative, they're sitting in the now division bench. And matter was placed in the same division bench. So matter was released.
By the same single bench or by? Well, there is a section 5 application to move this application. There is a delay for 92 days, my lord.
You're opposing?
Yes, I'm up, my lord, I'm appearing on behalf of the respondent petitioner. My lord, 90 days, my lord, there are no sufficient explanation, my lord, in the limit.
Affidavit. Use an affidavit.
Yes, I shall use. Right.
This is an application seeking
Right.
confirmation of
And my lord, Shubho Vijay to both of your lordships.
Same to you. Vijaya is over now. Now you are saying Shubho Vijaya.
Well, I don't have any scope to add to both your lordship.
When we
My lord,
list matter.
my lord, monthly list matter item number 11, but group 2 hearing matter I am led by Mr. Bhattacharya.
Hearing matter. You are for the
I'm for the university.
For the university. What is the issue?
My lord, regarding my lord, there are so many appellants. My lord, they were
Issue is regularization.
Oh,
In fact, the appointment was made for the regular post, but they were shown as contractual and artificial break for 1 day every year. That's the issue?
the court rejected your prayer.
Yes.
So you are in appeal. All paper books filed.
ready. 20
Paper book has-
Pursuant to a direction, my lord, previous direction, my lord, I'm just filing the supplementary
একটু দাও একটু দাও
Copy করবে দিয়েছি স্যার
তাড়াতাড়ি করে দিন না।
ফাইলটা কোথায় গো?
কপি করে বলো লাস্ট যে অর্ডারটা হলো স্যার
That is port trust. You also take
এই judgment
ওটা যেন
extortion
মনে আছে তো? ওই যেটাতে কিশোর is a supplementary affidavit or paper book
supplementary affidavit.
that has already been taken on record.
Yes, my lord. Today I am.
You are not the appellants.
No, my lord. Appellant direct. My lord, previously, my lord, there was a direction to file supplementary affidavit to the appellant. My lord, now, my lord, on the last occasion, my lord, the court directed the university
File a reply to the supplementary.
My lord, not only the reply, my lord, but also a supplementary affidavit
And an
explaining
affidavit
explaining
disclosing
paragraph number 6, 7, and 8 of the application filed by the university.
কোথায় সেটা?
That is on the record, my lord, that application for
No,
appropriate.
no, court directed you give a reply to the supplementary and the affidavit disclosing the What further documents were directed?
What happened, my lord? On the
You are the university.
I'm the university.
So state who is for the state? You are run on state fund, na?
Yes, the state presence is required, my lord. সেটা কে ছিল? স্যার এই মামলায় কে আগের দিন তো স্টেট অ্যাপিয়ার করেনি, বাট
Check up Mr. Chattopadhyay who in the read court who appeared.
91-95.
You have served upon the state. Bardhaman University.
সেটা হচ্ছে টাকা যদি স্টেট যদি স্যাংশন দেয় আমাদের দিতে
Now,
হবে।
Mr. Bhattacharya, what do you want to file now?
মানে supplementary affidavit explaining matter the paragraph 7-8.
That is the reply you have filed.
The
No, not the
university, in
reply.
fact, will not really supporting our stand. That's my understanding.
So what is the supplementary evidence you have already filed?
Because the documents are complete in terms of the order of the court. Now, if you Lord should desire, and of course, the state's presence is necessary.
Now, where is your supplementary evidence, Mr. Bhattacharya?
Already, my lord, file, my lord. Supplementary evidence already filed.
Reply to the
আরে একটা শোনো এটা চার্জ করে যশোরদের ধরিয়ে দাও, খুঁজে মুশকিল।
স্যার আপনার কাছে অর্ডারটা আছে স্যার একটা দিন।
There was এটাতেই annex করে দিন।
Supplementary affidavit filed by one Imran Ali. দেখুন,
That is the writ petitioner appellant.
this petitioner appellant.
And the affidavit disclosing the document.
Pursuant to the order dated December 2024.
All right, we will take it on record. We are keeping it in the supplementary list. You intimate this order to the state respondents. On that day we finish.
And may get the advantage of my lord's judgment.
Pardon?
My lord's judgment is on the issue.
We পেয়েছো? নামটা পেয়েছো?
বার করে নিয়ে আমাকে দিন।
So, Mr. Bhattacharya, you have filed one affidavit.
Yes, sir.
And both you've done a 2-in-1 basically. In the last order, you were to file a reply and an affidavit
I have
disclosing
not
the
filed the reply.
correct. So this is you've combined both into this.
No, my lord, not both, my lord.
So you don't wish to file a reply to the supplementary.
Because those are the documents, my lord. Those are the documents.
Mr. Bhattacharya.
ডেকে যাও 12 তো করলাম লিস্টটা ডেকে যাও কি আর what happened?
I was in that matter with Mr. Bhattacharya.
That matter you were there? Oh. নামটা ঢুকিয়ে দিই
Lord, I'm paying for not today, my lord. Mr. Shubho Bhogas Lahiri, my lord, appearing is not come today, my lord.
Yes.
Lord, him is my lord. Get this.
Okay, क्यों नहीं लगा নম্বরটাই না দিয়েছি অসুখ যেমন ছিল এটাই তো শেষ করে অর্ডার দিয়ে দিল অনলাইন লিস্টে টোটালি ফিক্স করা ছিল হ্যাঁ 76টা তো হয়ে গেছে তাহলে লিস্টে দিচ্ছে আছে
সেপ্টেম্বরের ফার্স্টে বেরিয়ে গেছে সেপ্টেম্বরের মান্থলি ডিসকাউন্ট
এইগুলো কি করেছিলাম গো
Milord, we also am seeking leave to file appeals offline, Milord, because it is
no,
not.
that cannot be done.
Milord, only 2 computers are available, Milord. It is not possible, Milord, to file it within the course of the day.
The needful be of that.